Hi, everybody. My name is Milena Odino. I'm the Business Information Officer here at the World Trade Center, Winnipeg. I would like to begin today's webinar with our land acknowledgement. We acknowledge that we are gathered on the lands of Treaty 1 territory and that Manitoba is located on the traditional and ancestral lands of the Anishinaabe, Anishinaabe, Innu, Denesilan, and Dakota Oyate nations. We acknowledge that we are also on the homelands of the Red River Métis and that northern Manitoba includes lands that were and are the ancestral lands of the Inuit. So Centerport and the World Trade Center Winnipeg team respects the treaties that were made on these territories and acknowledges the harms and mistakes of the past and present throughout our nation. So thank you everybody for joining our webinar, Unlock Your Workplace Rights, Manitoba Employment Standards Essentials, which will be presented by Marina Kelly-Zimberg and Monika Stashak, Employment Standards Officers from the Manitoba Employment Standards Office. So just before we begin, I just want to share a couple of housekeeping items. So number one, please send all of your webinar questions directly in the chat box. It should be at the top of your screen, and we'll try to answer as many as we can. And then we also have a Q&A session at the end. And lastly, you'll receive a PDF copy and a recording of this presentation within the next week. So now it's time to start our webinar. Welcome, Marina and Monika. The floor is all yours.
Thank you.
Yes, thank you for the introduction and to all for joining us today to learn more about employment standards legislation in Manitoba. So as stated, employment standards, when we receive claims, we're a third neutral party that investigates them. So we do not advocate for employees or employers. We base this on our the navigation of the legislation. So we help employees and employers learn about their rights and responsibilities in the workplace. We enforce minimum standards that apply to most employees in Manitoba. However, it does not cover every aspect of every workplace and relationship, such an example, independent contractor. And we also do not allow employees and employers to agree to work for less than the minimum standards. So there are several topics today that we will be reviewing. Minimum wage, payment of wages, ending employment, just cause, hours of work or overtime, breaks and daily of rest, vacation, general holidays, Remembrance Day, leaves and absences, young workers, and the Worker Recruitment and Protection Act. Okay, so now going into the first slide. Minimum wage. So employees cannot be paid less than minimum wage, but can be paid more. Minimum wage is different in some construction workers and under apprenticeship agreements. You can be paid through a salary or hourly wage, or by incentive and piecework. That's normally relating to commissions. How it's done is tied into inflation and is reviewed annually, effectively, usually every October 1st. So past year, prior to October 1st, it was $15.80. Currently, it is now $16 per hour. Now payment of wages. So employers must pay employees at least a minimum or at least 2 times a month. So that's either biweekly or semi-monthly. Wages must be paid within at least 10 business days or operating days at the end of each pay period. Construction, however, it's 5 calendar days. Employers are not allowed to withhold employees' pay. So it is the employer's responsibility to keep and maintain the records demonstrating wages are being paid to the employees. So the employer is also required to provide the employee with pay statements at the end of each pay period showing regular or any overtime wages worked, to which the employee is being paid, and they have to demonstrate the employee's wage rate, deductions taken from each pay period and to show the gross and net amount. Okay, now going into pay statements. So this is just a copy or an example of what we would need to see in a pay statement. So if we were to do an investigation, we would pinpoint some of these details, like the regular hours worked, making sure that's clearly labeled on the pay statement, as well as the overtime hours worked. Rate of pay needs to be demonstrated on there. All deductions and reason for each deduction, and also the net wages paid. So this is just a brief example of what we would look for in a pay statement. So mentioning that we do allow deductions, like there are allowable deductions and wages. So the typical deductions employers does is income tax, EI, CPP. Another allowable deduction would be like court orders or garnishments that's occurred, or potentially recovering of pay advances or payroll errors, or any other direct benefit that is to the employee, like an example, health care insurance. So those are allowable deductions. These are some examples that we have that often we come across where deductions that employers cannot take back from employees. So like broken or stolen or damaged property, faulty or poor work quality, theft that's occurred, cash or inventory shortages, safety equipment or interest or other fees on cash advances or cashing checks. Another piece that's very common that we see is uniforms. So if the uniform is unique to the employer and the employers cannot charge for the uniforms, like an example, if somebody has a McDonald's uniform and it's specifically labeling as McDonald's, then that would be something that the employer can't charge for. If there is a dress code, that isn't unique to the employer, it would be the responsibility of the employees. So like an example, us, we're formal casual. So our employers, we don't expect our employers to pay for our clothing. So now going into the subject of ending employment. So when termination has occurred, notice must be provided when it occurs. So notice is the period of time to which the employee or employer is required to give before ending the employment. So all that is, and it's also dependent on the length of employment that the employees have been there with you, and taken into consideration if it's a continuous employment as well. Noting that all wages must be paid within the 10 days of termination. Notice period can be worked out by the employee, or wages in lieu can be paid to the employer as well. The amount of notice is based on the employee's length of service. Note that employers can also give the employee a combination of working notice or the wages in lieu, like 1 week working out the wages and then pay out the remainder amount. So this is a chart we have here on the notice periods. So a lot of times folks just think it's the typical 2 weeks and that's all that's required. However, like I mentioned before, it's not based on that. It's based on how long you've been employed there. So if you looking just at this chart here where it says if you're less than 30 days, no notice is required. However, if you're more than 30 days but less than a year, it's 1 week, and so on and so forth. It starts to increase more as the years go on, but noting that if the employer decides to provide a greater benefit, then they're more than welcome to do so. Also noting that that is something for the employer. Now, we get a lot of questions on the GI line around whether employees have to provide notice. And the question is, yes, they do have to provide notice, but note that there's nothing that we can address if they decide not to provide that notice. If they decide to terminate immediately, that would be something that you would have to more or less pursue through civilly. Note that earned wages cannot be withheld if the employee doesn't give notice. Layoff versus termination. This is a common question. So a lot of times folks don't really understand the difference. So a layoff is a true layoff would be a temporary break in employment with the intent of bringing them back, whereas a lot of times where that may not be the case. So termination is where you're permanently breaking the employment and with the intent of not bringing them back, and notice is required. Whereas layoff is an understanding that things happen, life happens, where, you know, if 8 weeks when you're on the termination, like if you're on a layoff and it's more than 8 weeks, then it's no longer considered a layoff. It's then considered a termination, and then notice is required for this. So there are exceptions to notice, and these are the most common ones. So when employment is fixed or has a specific end term, like an example, if you're contracted for only 1 year and you have a specific start and end date, and that end date you work all the way through to it, and the no notice is required. But another would be specific tasks. So if the employee was only hired specifically to do a certain project, then potentially, yes, no notice is required. Common ones in our exception is also people who are under construction. If you fall under construction, no notice is required. And then a more common one is termination due to just cause. So what is just cause? We get that a lot. So just cause is an extreme event that has occurred that has severed the relationship between the employee and employer. So the employee is legally required to notice. So if the employer is claiming that exception to notice, it's the employer's responsibility and duty to establish that their reason or the employee's conduct that happened was so serious that they could not reasonably work out their notice. The right to termination for claiming an exception to notice and like just cause, the employer has the right to end employment at any time. We're not arguing that. It's just being mindful that you can do so without cause as long as the appropriate notice is provided. So here on this slide, we have very common themes or reasons for why termination for just cause may happen, such as theft, dishonesty, violence, neglectful duty, disobedience, conflict of interest. Now I'm going into hours of work and overtime. So overtime, our standard is 8 hours per day, 40 hours a week. So note that depending on construction and depending on what type of employment, that can change. It's understanding what kind of role you do, and sometimes that mislabeling has occurred. Most employees are entitled to overtime wages if they work more than their regular hours. So regular hours are different in some industries, like I've mentioned, construction, landscaping, or it could bypass if there are some averaging permits or potential flex time agreements or bank time agreements. And there's so many different examples in relation to that, and we have great, terrific fact sheets on that can help guide you on that. So on just example here, it shows that the difference if under week 1, how the daily threshold isn't surpassed, however the weekly one is. And on week 2 here on the diagram, it shows how the weekly threshold isn't surpassed, but the daily is on that Friday, highlighting the 10 hours. So overtime is calculated on both daily and weekly, like I mentioned, thresholds. And the terminology, like such as full-time or part-time, is not defined in our legislation, and it doesn't matter if you are casual, part-time, full-time. If I'm a casual employee and I work 10 hours in an industry that has 8 hours per day, 40 hours per week, then overtime could be owed, and should usually is. Okay. More information on overtime. So how is overtime paid? So it's paid at time and a half, the regular rate. Note that overtime, you need permission to work it, and it has to be granted by the employer. Note that permission, though, can sometimes also be implied. An example of that, so say an employee has overtime hours on their timesheet, which has been approved and then paid by the employer, and the employer observes the employee working outside of their normal hours of work, but never addresses it, never communicates that they shouldn't be doing that, but has observed that they have done it. So another piece is typically employers are not required to work overtime unless the employer asks that piece. Overtime wages also apply to employees that are paid commissions, flat rate, or incentive pay. Reporting to work. So this applies when an employer sends an employee home before the end of their shift. So this can be common for, like, an example. This is something I see often is somebody comes into work, the employer is, or it's a restaurant, they come into work and the employer says, you know what, it's quiet, it's dead, you can go home. And the employees, say an example, scheduled for 8 hours, then under the reporting for work, under this legislation, the employee is required to be at least paid for the 3 of those hours. So if they showed up right at the start of their shift and the employer said, oh, you need to go home, and they were scheduled for 8 hours, then 3 hours are owed. Or if, say, the employee was only scheduled for 2 hours, then only 2 hours would be owed. Now breaks and day of rest. So employees are entitled to 1 day of rest each week, unless if you have a day of rest order, which you can apply through on our website. One break after every 5 hours of consecutive work is permitted, so they must be at least getting 30 minutes. It is not required to be paid. If it is paid, that's a greater benefit that we would uphold. And employees, so when we look at what is a break, this is really important to note. So a break is complete. They have the complete control to do what they would like. They have no connection to work. Like, it's not the case where if somebody is required to stay on at the workplace to while they take their break, it's a true definition of break is having that release of responsibility of the workplace, and you're able to do what you need to do on that time. So a good example of that, like I've already mentioned, is the employees would be able to leave work property and they can choose their tasks.
So for vacation, essentially there's two components. So there is the time and the pay. So if you have worked there for 1 to almost haven't completed yet your 5th year, you would be entitled to 2 weeks of vacation time. And the vacation wages is 2% per week. So for 2 weeks, it would be 4%. And if you've completed your 5th year, you would then be entitled to 3 weeks of vacation minimum, making your new vacation wage rate at 6% because you would have that 1 additional week. So essentially, vacation is calculated on your regular earnings and general holiday pay. It would not include overtime, and bonuses would only be included if they were considered to be a wage and not a bonus. So essentially, if a bonus was performance-based, then likely that would be considered a wage. You would get paid vacation wages on those. But if it was something like, let's say, a holiday bonus, then likely you wouldn't be entitled to be paid vacation wages on such a bonus. So the employers must give the employees their annual vacation within 10 months of it being earned. And if the employee and employer can't decide on the time that the employee would be on vacation, the employer can schedule the vacation for the employee as long as they provide notice 15 days prior to the scheduled vacation, and the vacation has to be at least 1 week long. As for general holidays, so those are the days where you would have this day off with your 5% general holiday wage. And if for most employees, if you work on a general holiday, you normally would be paid the overtime rate for all of those hours worked. There's also important to note that the general holiday hours that are worked do not count towards the weekly overtime. But they don't substitute a weekly day of rest as well. So there's 9 general holidays in Manitoba. There's New Year's Day, Louis Riel Day, Good Friday, Victoria Day, Canada Day, Labor Day, Orange Shirt Day, Thanksgiving Day, and Christmas Day. So again, an employer is always, they absolutely can give a greater benefit, because some people will say, well, I get, Terry Fox Day or I get Boxing Day. That would be a greater benefit. It's not something that is covered under the code, but certainly an employer can do so. So general holiday pay is calculated. Essentially, what would happen is the employer will look at the 4 weeks prior to the general holiday and provide 5% of the gross wages, so the regular gross wages, again, not overtime, and that's the amount that the employee would be paid. For employees that always work, let's say Monday to 5, 9 to 5, then they would be given just a regular day. For simplicity, but for employees who worked varied hours, then the 5% would come into, it would be the calculation to use. If the employee has a excused absence before or after the general holiday, then they would still earn that 5%. If there is an unexcused absence, then the employer would not have to pay for that general holiday. Again, for most employees, you will be paid the overtime rate for any hours that you worked on a general holiday. So there are some industries, like for example, restaurants, hotels, gas stations. So essentially, businesses that operate 24 hours a day, 7 days per week, they're continuously operating, then they would be paid their regular wages for the work on their holiday and given a different day off work with general holiday pay instead. There is one very important note here that Orange Shirt Day cannot be substituted for a different day off. So other days can. For example, this happens a lot for July 1st because it's not a static day, where if it happens on a Tuesday, most employers will then, survey the employees, make sure that at least 50% agree that they would prefer to have the Monday off instead of the Tuesday. Then it can be substituted that way. So a few considerations for the general holidays. So if the employee doesn't normally work on the day that the general holiday would fall, then they would get the next regular workday off with general holiday pay. If the general holiday falls on a weekday, then they would get a normal workday off with general holiday pay. And employers may substitute, like I was explaining, except for Orange Shirt Day, that has to be observed on September 30th. There is no exception. Remembrance Day is another topic that we will discuss. So most industries are not allowed to operate on Remembrance Day. Of course, there's exceptions. So things like hospitals, hotels, restaurants, emergency response, and retail must not operate between 9 a.m. and 1 p.m. So Remembrance Day can be treated somewhat like a general holiday, yes and no. So one of the differences is that if you don't work on Remembrance Day, you wouldn't be paid the general holiday wage. If you do work on that day, you would be paid 1.5% or times your regular rate, and you would receive that 5% general holiday wage as well. And another important note for Remembrance Day is that you must be paid for at least half of the hours that you normally would work. So if you normally worked 8 hours a day, you can't be scheduled for only 1 hour on Remembrance Day. You would have to, well, I guess you could be scheduled for only 1 hour, but you would have to be paid for minimum 4 hours. So minimum the half of what you normally would be working. We also have leaves of absences under the Employment Standards Code. So in this case, the employer must provide the employee time off once they indicate that they will be taking a leave. And the employee are able to return to their job held prior to the leave once the leave has ended within certain timelines based on the leave that you're taking. So employers must show that the leave has no impact on the decision to provide a layoff or terminate if that is the case while an employee is on a protected leave. So employers are not required to pay employees under the Employment Standards Code. This is a very common mistake, or the common call that we receive is that our leaves are very similar to the ones that are paid by employment insurance. However, we are two completely different organizations. So you would have to contact Service Canada in regards to receiving any type of EI benefits, EI sick benefits. So while it might be the same leave with the same number of weeks allowed, we still wouldn't be able to help you with those types of benefits. It's not covered under the Employment Standards Code. So in order to qualify to take a leave, you must also qualify for a leave. So essentially, we have several different leaves under the code. So most of them will require that you be employed for a certain amount of time, and then that you meet the specific requirements. So the definition of family for one of the leaves is very broadly defined under the Employment Standards Code. So essentially, it could be spouses, common law, children could also be stepchildren, parents, grandparents, siblings, step-siblings, aunts, uncles, niece, and nephew. It also could be someone who is not related, but who the employee considers to be a close relative. And another important note is that the employer cannot control when the employee is to take a leave. So let's say it would be something like a leave for serious injury or illness. An employer can't ask you, to schedule let's say your surgery at a time that is less busy for them. It would be if the the doctor says that the surgery is on such and such a date, then the employer needs to respect that. So the most common leaves are maternity leave, parental leave, family leave, bereavement, compassion care, and the long-term leave for serious injury or illness. So I'll just go through these quickly because you can see the chart here. So you need to have worked at least 7 months to qualify for the maternity and parental leaves. So maternity leave is for the employee that will be giving birth, and the length of the leave is 17 weeks. Parental leave would be for any parent that is caring for their child, and that is 63 weeks. So maternity leave, if the same parent is to take both leaves, then parental leave would immediately follow parental leave. For family leave, this is essentially 3 days in a calendar year where an employee essentially would be like a sick day. So it could be to care for yourself or anything related to your family responsibilities, or you need to care for yourself. And the qualifying period is 30 days. Bereavement leave is also a 30-day qualifying period, and an employee can take up to 5 days per family member loss, or the loss of a pregnancy. So for every person in your family who passes away, the employee is entitled to up to 5 days per person. For compassionate care leave, the qualifying period is 90 days, and the length would be up to 28 weeks. And this would be for an employee to care for a seriously ill family member. And the long-term leave for serious injury or illness has also 90 days qualifying period, can be up to 27 weeks. And this would be for the employee who, like I was giving the example, requires a surgery or has a long-term serious injury or illness that they need to take care of. The lesser common ones, but that's still the types of leaves that we have. There's also the interpersonal violence leave, where the qualifying period is also 90 days. And the length of leave can be 10 days and 17 weeks. And this would be for employees to address situations of violence in the home. And then leave for citizenship, qualifying period is 30 days, and you can have 4 hours essentially to attend to your citizenship certificate ceremony to receive your certificate. And then the leave related to the death or disappearance of a child, the qualifying period is 30 days, and it can be 104 weeks. 52 weeks. So this is for parents that are dealing with the death or disappearance of a child that has resulted because of a crime. There's also leave for reservists, 3 months qualifying period, and that could be for any period of time when that person is needed for service, and that would be to report to the Canadian Forces Reserve. Leave for organ donation, again, 30-day qualifying period, can be up to 13 weeks, and that would be for any employee that's donating an organ or donating tissue. And then a leave related to critical illness, there's a 30-day and 90-day, because there's 2 different leaves, and then it could be for up to 37 weeks or 17 weeks. And again, that would be for caring for a member to provide care and support to a critically ill child or adult. There's also the public health emergency leave and vaccination leave. There was no qualifying period. There still is no qualifying period. And it would be 3 hours for the vaccination appointment. And that would be for employees that are absent from work due to the side effects from the vaccine, and the 3 hours to actually have the appointment to be vaccinated. Next section will be our young employees. So essentially, if you are under 16 years old, then you must complete a young worker readiness certificate course before you can begin working. The link is available on our website as well, but it is through Safe Work Manitoba. There's also just some general rules. So if you're between 13 and 16 years old, you cannot work between 11 p.m. and 6 a.m. And there is a maximum during the school year of 20 hours per week. And there are some industries where if you're under 16 years old, you cannot work in. And if you're 16 to 18 years old, then you don't have to complete the Young Worker Readiness certificate course. And the rules change a little bit where you just can't work alone between 11 p.m. and 6 p.m. There's no limit of hours that you can work. And there are still some industries where you're unable to work until you are 18 years old. So for examples, if you're under 16, you cannot work on a construction site or in manufacturing, drilling or service rigs, scaffolding. So you can't maintain or remove trees or shrubs, can't work at heights that are over 1.5 meters, work with herbicides or pesticides, or work without direct supervision, adult supervision. And if you're 16 to under 18, then you still cannot work in forestry, in saw or pulp mills, in confined spaces or underground mines, neither on the face of open pit quarries, in asbestos abatement or removal, and you also cannot work alone between 11 p.m. and 6 a.m. The next section will be our Worker Recruitment and Protection Act, so WRAPA for short. Essentially, this is when employers are seeking to hire employees that are foreign workers, that are child performers, that will be temporary help agency employees, or possibly clients of employment agencies. So this is done through registering and licensing businesses associated with workers who are more vulnerable to exploitation. Children and foreign workers are considered to be vulnerable. It places added responsibilities on the employers and recruiters and agencies not to charge workers and performance fees that are prohibited, and to maintain detailed records above and beyond what is required under the Employment Standards Code. So for the WRAPA overview, essentially, we look at licensing, registering, and permitting, and looking at fees. So that regulates employment agencies, temporary help agencies, child performer recruiters, child talent agencies, foreign worker recruiters, and the businesses that are hiring temporary foreign workers. As for registration and permitting, so if a business wants to hire a temporary foreign worker in Manitoba, they must register with Employment Standards and be given permission to hire the worker. This gives us the opportunity to make sure no unlicensed third parties are involved in the process, and to make sure that fees are not being charged to the workers, and to make sure that the business is also in compliance with our legislation. So business registration from Employment Standards is free. The federal government charges businesses a fee to conduct a labor market impact assessment, and LMIA, most commonly known as. And they might set terms and conditions of employment that are greater than what is in the Employment Standards Code. Employers must pay these requirements to the federal government, so not through our process. The information that is collected during this process is who is requesting the workers, the involvement of any recruiters and third parties, the number of workers, and also the types of jobs that they'll be performing. And this is done to maintain a record of who is employed, who is employing these vulnerable workers. And also, there are some instances when we can follow up with the workers and ensure that they haven't been charged any fees, and that they are being paid accurately, and that the employers are following the requirements under our legislations. So I would say that the most common type of exploitation that we see at Employment Standards is basically economic exploitation by way of employees not being paid properly, or fees being charged to the foreign workers. That's covered under the RAPA legislation. It prohibits fees being charged to workers and includes direct fees, so the cost of the LMIA or other costs associated with hiring the worker, or indirect costs for goods or services that can't be distinguished from a direct fee. So the easiest way to conceptualize this is that fees cannot be charged. So for example, if an employer hires a recruiter to find a worker, then the employer cannot charge the worker for that cost. The only exception are child talent agencies, but not recruiters, who can charge fees for other services unrelated to finding the job for the child talent. So that might be things like talent or modeling classes, for example. If unlawful fees are found to have been charged, those fees can be ordered to be paid back to the worker. So this concludes our presentation. We are open to any questions. We also want to note that on this last slide is our general inquiries line. So the toll-free number and the other number. Then you can call at any time, Monday to Friday, 8:30 to 4:30. A live person will be answering you. You can also send your questions by email at employmentstandards@gov.mb.ca. And like Monica was saying earlier, we do have really a lot of great fact sheets on the website, which are really helpful depending on the type of information that you're looking for.
Please note that if we don't we won't probably have the entire time to answer every single question, and there are going to be, depending, specific situations with complex answers that we won't be able to answer that in detail and give definite answers. What we will be doing is answering questions generally, and if we don't get to your question, you're more than welcome to call the general inquiry line, where another officer can be contacted and you can ask your questions.
Exactly.
Hi, there are a couple of questions, so great presentation. Thank you so much. So somebody asked, I'm pretty sure this was regarding slide number 15. If that gives you an idea so they're asking, how about taking workshops after work hours in the field of childcare?
So there's a few components here. So workshop, is the training directed by the employer? Is it mandatory? Is it something that's specific to the employer? Would it be seen as work? Like there's a different, that's what we would look at specifically for that situation. We would have to determine. So you're going to like my answer. It depends. It depends.
Yeah. And I would say in most of those circumstances, when you're asked to, let's say, work after hours or attend training, and you're not sure if you should or shouldn't be paid, then employees always have the option. Well, they can discuss with their employers, of course, to begin with. Or you can always file a claim. So essentially, to get an absolute definitive answer, most of the time you have to file a claim, because we have to go through the entire investigation process to determine if you should be paid for those hours or not.
Okay, perfect. Thank you. And then Amanda, you have a question?
Hi, yeah, thank you so much. And thank you for the presentation. A lot of work has gone into this. I really appreciate that. My question is regarding travel. So if people work in a remote area and they have to spend a day to travel to work and a day to travel home, is that considered work hours, and do we have to pay them? Or if they agree, can we get away with not paying them? I guess is what I'm trying to say.
So likely it would be considered work hours, but if it's driving to, let's say, a remote location like you're talking about, then it could be that those hours are paid at minimum wage and not at the employee's regular wage if they're being paid more than minimum wage. But normally your travel time, if you are traveling for work, it normally would be considered working time.
Okay, thanks.
Perfect. And then somebody in the chat's asking with regards to overtime in scenario 2, is it the 2 hours that is overtime, even though the weekly hours are below 40?
And that was slide 15, correct?
I'm
Yeah.
pretty sure, yes.
Yes. Okay, so where's the confusion line?
Number 2 here.
Number 2. So yes, on this specific example on worked week, so this is where the weekly threshold isn't going over. So if you notice that the total hours worked, it's not over 40. However, on Friday, they're working 10 hours. So it's meeting that daily threshold because it's over 8 hours. So it would be considered 2 hours of overtime. So that's how that would, we would look at that, because not all the time folks beat that weekly threshold. Sometimes it's the daily threshold that we look at too.
Okay, perfect. And then just a follow-up, can overtime be in form of banked time?
So a bank time agreement is an agreement that the employer and the employee has to have. The employer has to make sure that they follow all the qualifications for a bank time agreement. And what that happens if you were to work 2 hours of overtime, then you would bank that at time and a half, and you get that time off paid at a later date. That's something that the employees have to take within the 3 months, or it has to be paid out. Yeah, I think that's all I can think of at that time.
Yeah.
And there's quite a few questions, so just stop me at any time. But another question is, are there any guidelines for foster parents to be? What benefits are they entitled to if they're currently full-time employees?
What types of benefits does this person mean?
I'm not quite sure. If the person who asked this question could maybe elaborate in the chat, or even feel free to unmute yourselves. Or else we can move on to the next question. I'll just ask another question in the meantime.
Sure.
Does the bereavement leave apply to hourly waged employees at a motel?
It applies to all employees.
Yeah.
It doesn't matter the position or title. It applies to all employees.
Right.
Perfect. And then Haley's asking up to 5 days for bereavement leave. We have 3 days stated in our HR manual. Is that wrong?
Yes, it's up to 5.
So it could be, the only exception would be that if you are covered under a collective agreement, then you wouldn't fall within the Employment Standards Code.
Now, if the employer, please note that a lot of these leaves aren't paid. So if the employer decides to pay for your bereavement leave or any leaves, that's a greater benefit that we wouldn't uphold, but your entitlement is the day off itself. So if the employer, like I mentioned at the very beginning, the employer cannot have you contract or do a contract that's less than the employment standards. So if it's less than what our minimum requirement is, that they're not, then that's incorrect. They have to be following our minimums. If they provide greater, that's fine.
Okay, perfect. Thank you so much. And then I think someone just wants to know exactly what is a foreign worker. Do they live in Canada and have a work permit already, or they don't have a work permit?
So a foreign worker is somebody who essentially isn't a Canadian citizen, would be considered a foreign worker.
Yes.
Okay, perfect. Thank you. Another question, is it mandatory or voluntary for an employer to register with Employment Standards if they want to hire an open work permit holder, somebody who's eligible to work for any employer?
Depends on the program you're applying for. So like an example, the federal government just launched this new program, a pilot program, where it's saying you're required to register with us, and that specific program, you can be in an open work permit to get that. So it depends. You're gonna like that. You're gonna hear that a lot. It depends on the agreement that you're applying through with the federal government. If it's saying for you that you have to register with us, then then you have to register with us.
I would suggest for that employer to take a look even at the registration application, because that will kind of guide you into do these streams seem to make sense for the type of employee that you're trying to hire, then likely you should be filling out this application. But if it seems completely unrelated, then maybe it wouldn't fall within the RAPA legislation.
Okay, perfect. And just a few more questions, sorry. But somebody is asking, can you go over a definition or a criteria of what management is under section 19(1), which states no implied right to require overtime of the ESC. So you said most provinces appear to exempt managers from overtime, but are not clear about where that boundary lies, especially for middle management.
So it depends. Like when we look at the definition of management, we look at the aspect of control. We have a really great fact sheet on how we would look at management and those exemptions. So what I usually tend to, like, if I'm investigating a management or an overtime concern, I usually tend to have the employer and employee review that fact sheet to really suss out. And like, I will also gain information to see where that control lies. And sometimes it's not always black and white. Sometimes there's a lot of gray, and it's a scale of, oh, this person has a lot of control here, but not as much control here. Like, I can't give specific, like, if this person's asking for a specific example for their specific situation, I won't be able to answer it. It depends. I would have to investigate it. And the best way for us to look at that is if somebody files a complaint. But like I mentioned before, there is a fact sheet, and I encourage everyone to read the fact sheets.
Yes, because it will be exactly, it kind of guides our investigations is what's in the information that's in the fact sheets as well. It just simplifies from reading through legislation. But that's what we would be looking at is the examples that are on the spreadsheet, like Monica was saying, like how much control do they have? Are they able to represent the employer? Are they in charge of budgets? Things like that.
Okay, thank you. And then for that previous question that I asked about the foster parents to be what benefits. So I think they meant sick leave with pay, dental coverage for the foster family.
So there's nothing, so health benefits are a greater benefit. It's not a minimum requirement. So those types of benefits are based on the employer. So the employer can choose to provide things like Blue Cross or Great West Life or those kinds of health benefits to their employees, but it's not a minimum requirement.
Perfect. And then somebody's asking just a follow-up. We have recently hired 2 staff that would qualify as foreign workers. They live in Canada and have a work permit, but are not currently Canadian citizens. Would we need to register?
Well, if you're already hired them, then probably not. Like if they're on a PR, we mainly look, like if you look on the actual application itself, typically all of those streams that you're applying for is for closed permits or re-registering for the worker you already have that was on a closed permit. You would have, in order for you to even gain this foreign worker on this closed permit, you have to first go through us and the LMIA. If they're already on an open permit and are applying through that pilot program through us, then potentially, yes, they have to. But that's something that would be between the employee and the employer. Like if you have an employee who's on a closed work permit who wants to go through this other program that could potentially lead to open permit, then that's something, yes. But you would have to first probably, like if you're not too sure about what you need to do for that in order to qualify for that, then that's something you would have to look into at least through the federal programs. But there is a list on our application that says all of the different programs that specify that you have to be registered through us. And I highly suggest for folks to look over that if that's what they're trying to figure out.
Okay, perfect. Thank you so much. And I think this is the last question, but what is the time frame for correcting the payroll error of overpayment? Does it have to be in the same calendar year or fiscal year, or can they make the correction years later?
There is none. So I recently went through this. There is no time limit, but it's important to note that you have to actually make sure that it's a true payroll error. So, and looking at that definition, because there's a lot of times where employers label it as a payroll error, but it's not. And that's something to consider, is if it is actually a true error.
Okay, sounds good. Do averaging agreements need to be reviewed and approved before they can be in place?
So averaging agreements, like we have a template on our website that shows how we would look at an averaging agreement, because there's quite a bit of criteria that, for an example, if I were to investigate and if they don't meet our minimum requirements for like the little checkbox I have in my head of what you need to have in an averaging agreement, and if you do not reach that, then I uphold overtime.
Right.
And it's really important that you follow everything in that agreement. And that's why I usually tend to tell employers, use our template. It's very clear cut and it's already there, and it's our language. It's our wordage that we would use.
And on the website, there's also, because if you're applying for an averaging permit and not an averaging agreement, then we also differentiate on that on the website and in that application form, if you're wondering if you need a permit or if you only need the averaging agreement.
Okay, perfect. Thank you. And I think that's it for questions in the chat box, but if anybody still has a couple questions, they can also feel free to unmute themselves. But I think that's all for questions. So I included a couple of events and webinars that we have in the upcoming couple months. So yeah, that's it for questions. Thank you so much to everybody who joined this webinar, and thank you, Marina and Monica, for the insightful presentation. Hopefully we will see everybody in the year 2026.